चलिए आपको सीधा लाइव लिए चलते हैं जहां 370 धारा के ऊपर बातचीत और चर्चाएं चल रही हैं।
The following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state, which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the state constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination, as understood by the definition of sovereignty, exists by which the state is subordinate to the Indian Constitution first and only then to its own Constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Call was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose, to provide for an interim arrangement